I've been covering this beat for decades, and let me tell you, what in the Sam Hill is going on up at the Supreme Court these days? Here we are, on December 26, 2025, and the highest court in the land is still hemming and hawing over whether the most popular rifle in America, the AR-15, and standard magazines are protected by the Second Amendment. That's right. Cases challenging bans on these common firearms and magazines have been relisted multiple times, surviving conferences where other gun cases got the boot. It's like watching the government move slower than molasses in January. I've been around long enough to know that when justices relist a case over and over, it often means something's brewing. Maybe a grant, maybe a strong dissent if they deny. But common sense tells us this issue ain't going away. It's all part of the same tangled mess in Washington and state houses across the country, where politicians keep trying to chip away at our foundational rights. Stick with me today as we break down the facts, dig into why this matters so much, and look ahead to what could happen next. By the end, I'll share the hidden truth about whether Justice Kavanaugh's promise to tackle this soon is holding water, or just more hot air. Well, let's start with the plain facts of what's unfolding right now at the Supreme Court. The main case we're talking about is Viramontes versus Cook County. That's the challenge to Cook County's ordinance making it a crime to sell, transfer, or even possess so-called assault weapons, including the AR-15, America's most popular rifle. Plaintiffs, everyday citizens backed by groups like the Second Amendment Foundation, argue this ban doesn't just regulate, it outright outlaws common rifles that law-abiding folks use for self-defense, hunting, and sport. They say it flies in the face of landmark decisions like Heller and Bruen. This lawsuit kicked off back in 2021 in federal court in Chicago. By 2024, Illinois piled on with its own statewide ban overlapping Cook County's rules. The Seventh Circuit upheld it all, claiming AR-15s are too militaristic for Second Amendment protection. Now here's why that don't sit right with me. That kind of thinking wasn't part of Heller or Bruen at all. Petitioners pointed out the circuit courts are split and confused, some saying these rifles are protected but restrictable, others saying they're not arms at all. Cook County fired back, saying no real split exists, and the case is a poor vehicle because plaintiffs supposedly rushed procedures without enough evidence. But at its core, this asks the Supreme Court to settle once and for all. Do Americans have a constitutional right to own AR-15s and similar semi-automatics? Then there's Duncan versus Bonta, the long-running California magazine ban challenge. After Bruen, lower courts kept upholding bans on magazines over 10 rounds, calling them accessories, not arms. Both cases went to conference weeks ago, alongside others like machine gun and short-barrel rifle challenges. Those others got denied quick, but these two? Relisted. Not once, but multiple times. They survived conferences, got pushed to new ones, and as of now, eyes are on early January for the next move. Data from past terms shows relists boost odds of a grant, 31 to 43% for one relist, even higher for grants overall. Multiple relists can signal interest or brewing dissents. These surviving where others didn't? That's potentially good news, folks. The court could have denied outright, but didn't. One has to wonder, is this a sign they're gearing up to hear it, or just delaying the inevitable? Now let's roll up our sleeves and dive deeper into why this ain't just legal mumbo-jumbo. It's about your rights, your safety, and who's pulling the strings. Follow the money and power, as I always say. These bans target the AR-15, owned by millions of hardworking Americans for lawful purposes, protecting the homestead, hunting like our granddads did, or just target shooting with the family. Back in my day, common sense told us the Second Amendment protects exactly these bearable arms in common use. But listen to what the lower courts said in these cases. The Seventh Circuit called AR-15s predominantly useful in military service, so not protected. The Ninth in Duncan said big magazines are mere accessories. No gun needs them to function. Now here's the hypocrisy that gets my goat. Heller clearly said the Second Amendment covers arms in common use today for self-defense, not just founding-era muskets. Bruen demanded history and tradition, not interest balancing or militaristic labels invented yesterday. Who benefits from kicking this can? Politicians in blue states and counties, racking up points with anti-gun crowds while ignoring that these rifles are used legally, far more than illegally. It's like requiring a license to speak freely. Makes no sense for safety when criminals don't follow laws anyway. And that military-style talk? Pure scare tactic. Semi-automatics have been around over a century, common long before any bans. Justice Kavanaugh himself said after denying a Maryland case that the time would come soon, in a term or two, to address rifle bans. Petitioners latched onto that, pushing Viramontes as the vehicle. Yet here we are, relists piling up. Reminds me of when bureaucrats flip-flop more than a fish on a dock. If the court denies again, it lets conflicting rulings stand, confusing law enforcement and citizens alike. But if they grant, could finally apply Bruin properly, striking these bans as unhistorical overreaches. I've seen it all. Governments always claiming public safety while eroding freedoms. This matters because the Second Amendment isn't going anywhere. It's what makes America America. Question the narrative, folks. Are these bans really about safety or control? All right, transitioning here to the road ahead. What could this mean going forward, and why should you be paying attention? These cases are headed likely to an early January conference, perhaps the 9th or soon after holidays. No December end conference, so 2026 kicks off with this hanging. If relisted again, odds stay decent for a grant, especially with past data showing interest. But multiple relists climbing could foreshadow denial with dissents from justices like Thomas, Alito, Gorsuch. They've signaled readiness before. Worst case, denial lets bans stand in places like Illinois, California, Cook County. More states might pile on, chipping at common arms till only antiques are protected. That's a darn shame, folks. Law-abiding grandparents unable to pass down reliable tools for family protection. Best case, grant review, and applying Heller-Bruin straight strikes them down. AR-15s in common use, protected, magazines essential to function? Same. No historical tradition of banning common firearms. My verdict, hard-hitting as always. The Supreme Court needs to step up. Avoiding this like the plague, despite Kavanaugh's words, smells like empty promises. Common sense and the Constitution demand protecting popular rifles and magazines. If they punt again, it's a pattern of system failure. Courts not enforcing rights, leaving us skeptical, hard-working Americans wondering who benefits from inaction. But there's silver lining in these relists. Interest seems there. We'll know soon. The system's got its flaws, relists, delays, conflicting circuits. But we're here to shine a light on it, talking straight like your wise uncle at the kitchen table. Will the Supreme Court finally grant these cases in January or keep kicking the can? That's the question we're all waiting on.